Court does call the case of the People versus Hector Gonzalez.
This is how courtroom days often begin. Quiet, procedural, almost casual. But don't let that fool you. These opening seconds are deceptive. What looks like routine docket management quickly turns into a revealing snapshot of how fragile a defendant's situation can be when multiple cases and warrants collide. Judge Simpson's tone here is dry, almost joking, but make no mistake, this is a judge who runs a tight ship and expects everyone in that room to be prepared. The casual back and forth masks something much heavier underneath. Unfinished discovery, scheduling delays, and most importantly, a defendant who may not fully grasp how fast control can slip away. This case isn't just about one charge. It's about how procedural issues can snowball into real consequences, especially when probation violations enter the picture. And here's the question viewers should keep in mind from the very start. How many defendants walk into court thinking today is just another appearance, only to leave in custody? This opening sets the tone for a courtroom where small details matter, timing matters, and missed steps can cost someone their freedom. Stay with this case, because it escalates faster than it appears.
Did I wake you? No, go ahead.
Not yet. Your Honor, not yet. Mr. Gonzalez, come forward. Stand here. Tell the judge your name. Michael Vincent on behalf of Mr. Gonzalez.
Hector Gonzalez, Your Honor. Good to see you, Mr. Benson. I haven't seen you for a while.
Lucky you.
Yes.
May I approach with the prosecutor?
Do it. Yes. We've had a bench conference.
Your Honor, we're going to need at least a week adjournment because discovery is incomplete.
All right. Is there somebody here with you, or did they send you on your own? No.
They left.
They sent you on your own?
Yep. Amanda took the day off.
Okay, there's supposed to be a green form filled out.
I'll fill it out.
Could somebody help Mr. Benson? Thank you. All right. Probable cause conference in this matter will be adjourned to July 17th, 2025, 9 a.m. Bond on this case will continue. Mr. Gonzalez, I was informed, and I think you have been informed that there's a violation of probation warrant. And that has no bond. So on it. Mr. Benson, did you want to, you don't represent him on that?
No, I don't, but I've talked. And Your Honor, on this present case, could he have at least $100 cash bond so he earns some time?
People don't have objection to the little cash bond, Your Honor.
I'll set his bond in this, on the case that I just called as a 1,010% bond. All right.
That'll be for time.
But on the warrant was issued by Judge Slay. There is no bond. It's violation of probation warrant. I'm going to remand you to the Washtenaw County
I'll
Jail.
try to get you a range.
The time that you can be heard in that
I
court.
gotta go with this.
All right, he's remanded.
This is the moment where the air leaves the room. Everything before this felt procedural. Adjournments, bond discussions, scheduling, but this sentence changes everything. A violation of probation warrant with no bond is one of the most dangerous legal positions a defendant can be in. Why? Because it strips the court of discretion. Judge Simpson isn't weighing sympathy here. He's enforcing a separate judicial order issued by another judge. Once that warrant exists, the hands of the court are effectively tied. This is a powerful reminder that cases don't exist in isolation. A defendant can do everything right on the current charge and still be taken into custody because of unresolved issues elsewhere. Notice how quickly the defense's momentum evaporates. Moments ago, they were negotiating cash bond. Now, the defendant is being remanded. Wait, for viewers, ask yourself, should probation violations automatically override bond considerations in a new case? Or should judges have more flexibility when the circumstances overlap? This is where courtroom reality collides with public expectation, and the result is often shocking.
Court calls the case of the People versus Robert Middleton.
Talking about hearing and on behalf of Robert Middleton.
Your name, sir?
Robert Middleton.
All right. What are we doing?
We would like to set this matter for a preliminary examination.
All right. All discovery is complete.
Yes, to our knowledge.
People have their witnesses available on the 15th. All right. Preliminary examination will be set in person July 15th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
It does call the case of the People versus Tanya Hall.
Good morning, Your Honor. Calvin Hall for the People.
Good morning, Your Honor. Just go on back to Ms. Hall. Judge, Ms.
Hall here, Judge? As you know, Miss Hall is an elderly lady. She lives at the Delana Center. I have no phone. I have no email. I would ask the court, you be the compassionate judge you are, if you would adjourn this 1 week. I will go.
We received a communication from Community Corrections indicating that your client presumably left a voicemail, or a woman, that Ms. Hall was in the hospital. She then received an email stating that she was discharged from the hospital. So I don't know why she's not here.
Judge, you know, I believe you know her circumstances. Would you give me 1 week? I will go to Delana Center and inform her. I have no other means of communication.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000. Cash surety. I won't have the warrant issue until the 8th. Give you time to try to find her.
Thank you, Judge. Appreciate it.
This exchange reveals one of the most human and controversial moments of the docket. On paper, a failure to appear is straightforward. No defendant, warrant issued. But real life complicates that simplicity. Here, we're dealing with an elderly defendant, possible hospitalization, no phone, no email, and limited communication channels. Judge Simpson walks a careful line. He acknowledges the system's need for accountability while also allowing a brief window for compassion. That delay matters. Once a bench warrant is active, everything escalates. Arrest, incarceration, and often additional financial burden through cash bonds. This pause is the court recognizing that justice isn't always black and white. But it also raises a critical question. How much grace should courts extend when defendants are vulnerable or disconnected from modern communication? And where does compassion end and responsibility begin? This moment shows judicial discretion at work and how rare and fragile it can be.
Have a good court.
I will do. Court does call the case of the people versus Anthony Turner.
The person they had waiting was not Mr. Turner. I do believe they're going to go back and get Mr. Turner. I don't know who the individual was standing there, but Stephanie Cannon on behalf of Mr. Turner. Your Honor, we are asking for an adjournment. He has been screened for mental health court. We're just waiting for the evaluation. Hopefully with that, the prosecutor and I can come to a resolution. We are waiting for it. They have to give it to us.
Will the 17th be enough time? You need 1 more week.
Your Honor, they indicated that they were going to try to get it to me today. When I checked, it was not there. So that should be fine.
Give you 2 alternatives. That should be fine.
Whichever
July
one,
17th, July 17th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls case of the people versus Mary Collins.
Christina Berry requesting petition practice for rule 8.120 under use of provision. Exactly.
Practice is granted.
Thank you, Your Honor. Christina Berry.
Kyle Burrell on behalf of Mary Collins. Ms. Collins, please say your name.
I'm Mary Collins.
Just so you understand, is a date and time set for probable cause conference. I have been speaking with EPA Ward on this morning about trying to come to some sort of resolution. We're asking for a 1 month adjournment here to let Ms. Collins.
1 month. Why do you need 1 month?
Which is basically to Ms. Collins basically needs to earn an offer at this point. And so we're giving her some time to provide that material and provide that proof. We can do less if the court.
Well, you're going to do whatever I say, but I'm just trying to figure out why you may need it.
Your Honor, I talked to Mr. Gavel about providing mitigation information. I was thinking that could happen in circuit court or down here, but we have to keep things moving, so I defer to the court.
And if the court would like to see it sooner, we can do that as well.
July 24, 2025, 9 a.m. Bond continued.
Thank you, Judge. Welcome to talk to you in the hallway.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Sean Newcomb.
Maybe Richard is looking for the people. Like about appearing with and on behalf of Sean Newcomb.
Please state your name for the record.
Sean Newcomb.
Has the court received the evaluations from the forensic?
I have.
We have nothing further to present in this matter. Set an order finding him competent.
Based upon a review of that report and the evidence submitted, the court would find that the defendant is at this time competent to stand trial, which specifically find that the defendant can understand the nature and objects of the proceedings against him and rationally assist in his defense. Therefore, the defendant is deemed competent.
Competency rulings are some of the most misunderstood moments in criminal court. This isn't about guilt, it's about mental capacity. The court is answering one narrow question. Can this defendant understand what's happening and assist their attorney? Here, the answer is yes, but notice the tension immediately afterward. Paperwork delays, late filings, judicial frustration. Judge Simpson's irritation isn't personal, it's systemic. Courts depend on precision, and when reports arrive late, they disrupt the entire docket. This moment highlights how mental health evaluations sit at the intersection of law and medicine, and how easily procedural missteps can derail progress. For viewers, consider this. Should a defendant's case move forward if administrative errors cloud the evaluation process? Or does the court have to keep moving to preserve order? This ruling pushes the case forward, but not without friction.
Do I have an order?
Yes, we've sent an order finding him competent
When did you send the order?
earlier today,
Oh, this morning in the middle of this docket.
before the
So right now, we really don't have an order.
before the doc.
I have to have my staff pull it off
Yes, Your Honor.
and stop everything to have it happen. Do you?
Oh, there you go.
What do you mean, there you go? You sent it this morning. Really? 9:12, even after the docket time start. Did Brown tell you to do that? He did, didn't he?
No, Your Honor, I did it.
You don't have to fall on the sword for him. All right, I signed the order that came in late.
Thank
All
you,
right.
Your Honor. We would like to set this matter for PCC.
Set a probable cause conference with 2 weeks be enough time for it. Set a probable cause conference July 17th, 2024, 9 a.m. Court calls the case of the people versus Jessica Hafner.
Good afternoon, I'm Amy Weiser, and I have
Morning, Judge Gavel on behalf of Ms. Hafner. He's approaching the podium. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
And Your Honor, I was just very recently appointed on this matter. We are asking for a brief adjournment at this time.
July 17th, 2025, 9 a.m. Bond continued.
Thank you. Judge, if the defense may be heard as to bond.
She's out. 17th.
Thank you, Judge. So Ms. Hafner currently has a no contact order with her children. Two of her children have a bad hereditary condition that requires constant and fairly advanced medical treatment. There could be a hospitalization or I believe you said a surgery sort of at any given time. Name of the disease was too complicated and long for me to even write down here, but we are asking for a modification to the no contact order to allow supervised contact for the purposes of medical treatment only.
Response from the people.
We would ask that the bond remain set where it is until we can have an exam or resolve the case.
I mean, is CPS involved?
Your Honor.
Has CPS?
I'm looking, a referral was complete at the time of this investigation.
Right.
They're basing it.
How many children are involved in this? One?
Elijah appears to be the victim.
There's only one child named in the complaint, Judge, yes.
As far as the victim. I mean, I'm also concerned, Your Honor, when the police came to investigate, the defendant took a long time to answer the door. She said that he was sleeping and they needed to check the welfare of Elijah. He was in his bed covered with a blanket, but not sleeping. They immediately observed blood coming from his face as well as tears from his eyes and blood touching. So we would ask that bond continue. I don't think it's appropriate for her to have contact with the patient.
And for what it's worth, Your Honor, Elijah is not one of the children that has the condition.
Well, but I'm not, you know what, I'll tell you, but I'm not going to change this, and I'm not going to change this on the fly, certainly. If you believe that it should be changed, file a written motion, I'll hear it, but I'm not going to do that. Motion for bond reduction is denied at this time, or bond modification is denied.
This is one of the most emotionally charged rulings of the day. On one side, you have a mother arguing for limited supervised contact with her children for medical emergencies. On the other, you have allegations involving injury to a child and serious safety concerns. Judge Simpson's refusal isn't dismissive, it's deliberate. He's signaling that bond conditions are not temporary inconveniences, they are safeguards. Courts are extremely reluctant to modify no-contact orders without a formal written motion and a full evidentiary hearing. Why? because once contact is allowed, even briefly, the court assumes responsibility for what happens next. This ruling underscores how family circumstances, no matter how heartbreaking, don't automatically outweigh public safety concerns. Viewers should ask themselves, if you were the judge, would you risk modifying conditions without a full record, or is strict enforcement the only way to protect everyone involved?
Understood. Thank you, Judge.
Court calls case People versus Bianca Rao. Court does call the case of the People versus Taylor Adams.
We're ready in this matter, Your Honor. On Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Taylor Adams. Mr. Adams, could you please state your name for the record?
Taylor Adams.
Thank you.
Your Honor, today is the date and time set for a probable cause conference. We have made great strides in working out a plea agreement. However, there's still some further information that we'd like to provide to the prosecution. So we'd ask for a 1 or 2 week adjournment so that can take place.
Probable cause conference without objection, July 17, 2025, 9 a.m. Bound to continue.
Thank you very much.
Thank you, sir.
Thank you.
July 7th.
Calls case of the People versus Brooke Bailey.
Assistant Public Defender Jay Bell, on behalf of Miss Bailey. Miss Bailey, can you please state your name for the record?
Brooke Bailey.
Your Honor,
She's waiving.
yes, she is.
Ma'am, you're waiving your right to a preliminary examination.
Say yes.
Yeah, yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
yes,
People also waive the right.
That's right.
Preliminary examination having been waived, defendant found over to circuit court on a single count.
We acknowledge receipt of information, wait formal reading, stand mute at this time, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for July 22nd, 2025, 1:30 before Judge Conte. Bond continued.
Thank you, Your Honor.
thank you.
Court calls case People versus April Black.
Your Honor, Alexis Plumey on behalf of Miss Black. And Miss Black, could you just state your full name? April Black. And Your Honor, today is the date and time for a probable cause conference. I do have a green sheet filled out. We are just asking for an adjournment for plea negotiation purposes, if we could go about 2 weeks. And then, Your Honor, I would like to address a couple conditions of bond.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Yes, Mr. Bond.
So currently, Miss Black is on a GPS tracking tether. And there is also an order that she not go to her mother's house, but not an order that she not speak to her mother. Miss Black lives about a block away from her mom. It's my understanding there was an incident immediately preceding this one that is still being investigated, where Miss Black and her mother would be the alleged victims. From what I understand, Miss Black was ordered not to go back to her mother's place because another person involved may live in the area. However, Miss Black has 4 children. She's still living a block away from her mother's house, and it is just inconvenient that she can't go over there and drop her kids off because her mom does help with childcare. And additionally, I feel that condition doesn't really relate to the charges in this case. So if you'd consider lifting that no-go to and removing her GPS tracking tether. And I don't believe there's any suggestion that Miss Black is a flight risk.
Response?
I would ask at least for this, at this point, the remain is currently set. When the police had contact with Miss Black, it wasn't a call regarding potential FA, but she was highly intoxicated, really aggressive with police, ended up doing police car, was combative. I'm just concerned, whatever the heck is going on at that 407 address, I would hate for there to be any sort of bringing up whatever dispute led to the initial police contact that would cause Ms. Black to have a negative impact on this case.
Motion for modification of bond, change in any conditions is denied. Bond will continue with its conditions.
Your Honor, if I could just clarify about the tether, I believe the tether is just tracking her. It's not an exclusion zone.
It's a location tracking tether.
Yes, so I'm not sure what purpose that.
So you
It's-
want me to redo the ruling I just gave? Is that what you're asking? How many times have you been before me? Yeah.
Few.
How many times have I ever done that when I finally ruled?
Understood, Your Honor.
Never.
Understood.
So I don't know why you think I'd start today. So are we done?
Yep, we're done.
Okay, thank
you.
This exchange is a masterclass in judicial finality. Judge Simpson makes it unmistakably clear. Once a ruling is issued, it stands. The defense attempts to reframe the GPS tether as just tracking. But the judge isn't interested in semantic arguments after a decision has been made. This moment highlights courtroom hierarchy. Judges expect arguments before rulings, not after. Pushing once the line is drawn risks credibility and goodwill. It's also a reminder that bond conditions aren't negotiated endlessly. They're imposed based on risk assessments, prior conduct, and judicial experience. This sharp cutoff reinforces authority and preserves courtroom order. For viewers, the takeaway is simple but powerful. Timing matters. The right argument at the wrong moment is still the wrong argument.
Court calls the case People versus Raymond Bowman.
Next report on the understatement.
Constable Bates on behalf of Mr. Bowman, Your Honor. Mr. Bowman, can you state your full name for the record?
My name is Raymond William Bowman.
I have before me a plea form. Is that what we're doing?
Yes, that's correct, Your Honor.
Plea form indicates that the defendant will plead count 2, possession of a weapon in a weapon-free school zone, 90 misdemeanor. And upon a successful plea, that charge count 1 would be dismissed.
That's correct, Your Honor.
Is that a correct statement?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Raymond William Bowman.
Sir, it is this court's understanding that you are pleading no contest to the charge of possession of a weapon in a free school zone, in a weapon-free school zone. Is that correct?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, sir.
Things about a no contest plea, I have to make sure that you understand. The first thing about a no contest plea that you have to understand is that it means that you are not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
This is one of the most legally dense moments of the entire docket, and it's easy for viewers to miss what's actually happening here. A no contest plea, often misunderstood, means the defendant is not admitting guilt but also not fighting the charge. In practical terms, the court treats it the same as a guilty plea for sentencing purposes. The key difference lies in civil liability. By pleading no contest, Mr. Bowman preserves some protection if a civil lawsuit follows. Judge Simpson walks methodically through every right being waived: trial, confrontation, appeal. This isn't formality, it's constitutional due process in action. Notice how careful the judge is, repeatedly confirming understanding. That protects the record and prevents future claims of coercion. Where you ask yourself, how many defendants truly grasp the long-term impact of this moment? One plea, spoken calmly in a courtroom, can reshape someone's future for years.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
You're under potential civil liability.
And understanding all of that, sir, you still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
I understand, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation in Wayne County.
Were you on probation at the time of this offense?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 4613-20. Any objection to the court having reviewed that report?
No, Your Honor.
No objections, Your Honor.
Counsel, there is not an indication of a school, the zone.
It would just be to the higher, Your Honor.
So accepting the higher,
There's no good misdemeanor for firearm.
so in looking at that, then, all right. Sir, if I do accept your plea, I have to have you understand that any sentence evaluation, if there were any or any recommendation, the court would not be bound by if you committed any misconduct as defined in the Michigan court rules. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, I understand.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied, Your Honor.
And based upon the police report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. The court will accept the defendant's plea to no contest plea to count 2. Count 1 is dismissed.
This ruling is a strategic trade-off. Count 1 disappears, but count 2 sticks, with sentencing looming. For defendants, this is often the calculated gamble. Accept responsibility now to limit exposure later. Judge Simpson emphasizes that sentencing recommendations are not binding if misconduct occurs. That warning matters. Too many people believe plea agreements lock in outcomes. They don't. The court retains authority until sentencing is complete. This is also where probation history comes back into focus. Prior violations don't vanish simply because a plea is entered. They follow defendants into sentencing and influence outcomes. Viewers should consider this. Does the justice system do enough to explain plea consequences in plain language? Or are defendants navigating life-altering decisions under pressure with limited understanding?
Pre-sentence investigation and report is ordered at 14A1. Probation sentencing in this matter will be
July 9th, 2025, 3 a.m.
July 9, 2025, 9 a.m. That's before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, my client is asking to be released on a PR while he waits his sentencing. My client is unfortunately very ill. He needs to go back to the hospital. He's actually due to have a procedure done today, correct, at 3 p.m. It's quite an intense procedure. He's also going to be
Is this the only thing holding him?
in here. Yes.
Judge, he has-
What do you mean here? Yes.
He has a hold out of Wayne for the DUI. He has been warned 4 times in this case already. So people think he should be held until at least see by probation.
The bench warrant, I believe, was due to him being hospitalized, and that's why he failed to appear previously.
The bench warrants in.
To be released to treatment from Wayne County. That's why, my sentencing, would need to be, I'm going to the Salvation Army. And I need it set up on Zoom. So if, you were to release me, I would go to Wayne County Jail and wait for treatment to pick me up. And then I would be at the Salvation Army there.
Anything else?
Nothing further, Your Honor.
I don't think it's appropriate given the defendant's track record in this case and the very fact that he has another hold to release this defendant. Therefore, the motion for bond reduction in this case at this time is denied. I'll be seeing him next week. So
Understood, Your Honor.
This denial rests on one word that echoes throughout this docket: history. Bench warrants matter. Even when explanations exist, hospitalizations, treatment needs, the court looks at patterns, not promises. Judge Simpson isn't dismissing the defendant's medical concerns. He's weighing reliability. Courts function on compliance. When appearances are missed repeatedly, trust erodes. This moment reinforces a hard truth. Credibility is cumulative. You don't lose it all at once. You spend it over time. Viewers should ask themselves, how much leniency should courts extend when personal crises interfere with legal obligations? And where should the line be drawn to protect the integrity of the process?
thank you.
Thank you, Your Honor.
Court does call the case. The people of the state of Michigan versus Grace Brenner.
Good morning, Your Honor. Nick Hammond, Assistant Prosecuting Attorney in Boston.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Brenner. Your Honor, can we approach?
Record should reflect we had a bench conference in this case. Defendant is not present. Court will issue a bench warrant for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately.
Yes, sir.
Today's courtroom docket wasn't about one dramatic trial. It was about the machinery of justice in motion. Adjournments, bond decisions, competency rulings, plea negotiations, and bench warrants all unfolded under Judge Simpson's steady hand. The common thread across every case was accountability. Whether it was a probation violation triggering remand, a missed court date leading to a warrant, or a plea entered with rights knowingly waived, each moment showed how procedural decisions carry real weight. These are the unseen turning points that shape outcomes long before verdicts are ever reached. Court isn't just about punishment, it's about rules, timing, credibility, and consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments. Bacha, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.